In this episode, we turn to a topic that many beginners assume belongs only to lawyers, even though it shapes everyday artificial intelligence, AI, governance much more than people first expect. When organizations train, buy, deploy, or use AI systems, they are not working in a vacuum where information and creative material are free to move without limits. They are operating inside a world where ownership, permission, licensing, originality, confidentiality, and attribution all matter, and those ideas sit very close to intellectual property, IP law. The reason this topic matters so much is that AI systems are built by learning from data, generating new material, analyzing existing content, and helping people create text, code, images, audio, and designs at speed. That means questions about who owns what, who may use what may be copied or transformed, and what may be kept secret do not appear only at the end of the process. They shape training choices, procurement choices, acceptable use rules, publishing decisions, product releases, and the boundaries of responsible governance from the beginning. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. A good place to begin is by understanding what IP means in practical terms. Intellectual property refers to legally protected interests connected to creations of the mind, such as written works, software, inventions, brand identifiers, designs, confidential know-how, and other forms of human creativity or commercially valuable knowledge. In ordinary business life, people often encounter these ideas through copyright, patents, trademarks, trade secrets, licensing, and confidentiality obligations, even if they do not use those labels every day. For a beginner, the most helpful way to hear this is that IP law helps determine what material can be copied, adapted, distributed, branded, protected, or kept secret, and on what terms. Once AI enters the picture, those questions become more complicated because systems may train on large bodies of content, generate material that resembles existing works, summarize or transform source material, or invite employees to place valuable internal information into external tools. That is why IP is not a side issue in AI governance. It affects the inputs, the outputs, the tools, and the relationships surrounding the whole system. Copyright is often the first branch of IP that people think about in this area, because AI systems frequently interact with text, code, images, music, video, documentation, and other expressive works that may be protected. Copyright generally concerns original expression fixed in some form, which means the law often cares not only about ideas in the abstract, but about how those ideas were expressed in actual works. This matters in AI because training data may include protected material. Prompts may ask systems to transform or imitate existing works, and generated outputs may raise questions about similarity, reuse, or derivative content. A beginner does not need to become a copyright specialist to understand the governance lesson here. The important point is that useful availability does not equal lawful freedom. Just because material can be found online, stored in a system, or copied into a prompt does not mean an organization has unlimited permission to use it for training, analysis, product generation, or public distribution. Copyright shapes what content may enter the system and how the resulting outputs should be reviewed before the organization relies on them. This becomes especially important when organizations think about AI training. Training can sound abstract and technical, but from an IP perspective, it raises very grounded questions. What source material is being used? Where did it come from? Did the organization create it, license it, purchase it, receive it under contract, or gather it from sources that may carry restrictions or unclear rights? A team may be tempted to think in terms of data volume and model quality alone, but IP law pushes a different question forward. Even if a large body of content would improve performance, does the organization have a sound basis for using that content in training, fine-tuning, evaluation, or retrieval systems? That question matters because the training stage can create risk long before any public output exists. If the sources are poorly documented, licensed narrowly, scraped carelessly, or mixed together without regard for rights, the legal and governance problem may already be present at the foundation of the system. Responsible organizations, therefore, do not ask only whether the model can learn from the material. They also ask whether they are entitled to use the material that way and whether they can explain that entitlement later. Licensing plays a major role here because many organizations do not rely only on content they created themselves. They may use datasets from vendors, code libraries, documentation sources, image repositories, transcription archives, design assets, or partner materials governed by terms that define how those materials can and cannot be used. A licensing issue is not always dramatic or obvious. Sometimes the problem is not outright theft, but quiet mismatch between what the organization wants to do and what the license actually allows. Material licensed for internal reading may not be licensed for training. Content acquired for one project may not be approved for broad reuse across new AI initiatives. Code available under one set of terms may create obligations if incorporated into a product or output workflow. This is one reason procurement, legal review, data governance, and technical teams need to work together. Licensing is where abstract questions about rights become operational. If the organization does not know the terms attached to its source material, then it is building a system on assumptions rather than on controlled permission, and assumptions are a weak foundation for scalable AI use. Outputs create a second major set of IP questions, and beginners should understand that these questions are not solved merely because the system generated something new on demand. Organizations often treat generated text, code, or imagery as automatically safe to use because the content was not copied manually by an employee in the traditional sense. That assumption is too easy. A generated output may still create concern if it closely resembles protected material, imitates a distinctive style too aggressively, reproduces confidential source content, or includes material that should not have been exposed in the first place. Even when the output seems original, the organization may still need to review whether it is fit for publication, shipping, commercialization, or external distribution. This is especially true in code, branding, marketing, design, education, and customer-facing communications, where the line between helpful drafting and legally or reputationally risky reuse can matter a great deal. Governance becomes stronger when teams treat generated output as something to evaluate rather than as something to trust automatically. The model may produce quickly, but the organization still carries the responsibility for what it decides to release or rely on. Ownership is another area where AI creates confusion, because people often want a simple answer to the question of who owns generated content. In practice, that answer can depend on the tool, the contract, the human role in the creation process, the type of output, the jurisdiction, and the intended use. The key beginner lesson is not to assume that machine-generated material enters the organization's control in exactly the same way as traditional employee-created work. Some outputs may be usable under vendor terms without giving the organization the kind of exclusive right it expects. Some may be open to reuse by others under the product model. Some may raise questions about whether enough human authorship or originality exists for the legal protection the business hopes for. Governance, therefore, should not promise more certainty than the organization actually has. Instead, it should build review practices that ask what rights the organization needs, what the tool terms actually provide, what human contributions shape the output, and whether the material is appropriate for internal support only or strong enough for external, branded, or product-level use. Patents enter the conversation differently, and they matter because AI can affect both invention and implementation. Patent law is often associated with novel and useful inventions, technical methods, and systems that meet specific legal requirements. And while beginners do not need to master patent doctrine, they should understand why the topic belongs here. AI may be used to help design products, suggest technical solutions, optimize processes, or generate code and system architectures that look inventive. At the same time, an organization may deploy AI within products or workflows that intersect with patented technology owned by others. This means IP risk is not limited to expressive content like writing or images. It can also touch how systems are built and what technical approaches they embody. Governance should therefore encourage teams to think about invention pathways, third-party technology dependencies, and review points when AI begins contributing to design or implementation in areas where patent questions may matter. The broader lesson is that AI can accelerate creative and technical work, but speed does not erase the need to understand whether the organization is stepping into someone else's protected territory or weakening its own ability to protect what it creates. Trade secrets are just as important, and in many real organizations they may matter even more day to day than patents. A trade secret is generally valuable information that the business keeps confidential because its secrecy supports commercial advantage. This can include source code, product plans, pricing logic, customer strategies, engineering methods, internal research, security approaches, and other knowledge the company does not want disclosed. AI tools create risk here because employees may paste internal material into external systems for convenience, ask a model to analyze or rewrite confidential drafts, or use third-party services in ways that move protected know-how into environments the organization does not fully control. Once that happens, the company may not only face exposure, it may also weaken the very secrecy that helped give the information its protected status. That is why trade secret governance and AI acceptable use rules need to connect closely. The issue is not only whether the tool is helpful, it is whether the use of the tool is causing the organization to give away something it was trying to protect, often without meaning to do so. Trademarks add another dimension because AI systems are increasingly used in branding, marketing, advertising, and customer-facing content. Trademark law concerns names, symbols, and other identifiers that help distinguish the source of goods or services, and the governance lesson for beginners is that AI can create confusion here in several ways. A tool might generate names, logos, slogans, or marketing assets that resemble existing brands too closely. It might produce content that misuses another company's marks or suggests affiliations that do not exist. It might also tempt an organization to move quickly into branding decisions without the review that would normally accompany public-facing identifiers. This matters because generated content can sound polished and commercially ready even when it has not been screened for brand risk, confusion, or misuse. A company that relies on AI for outward-facing creative work should therefore treat trademark review as part of release discipline, not as an optional extra after a campaign is already moving. A good governance model reminds teams that brand creation is not only a creative act, it is also a rights-sensitive act with external consequences. Contracts and terms of service sit right alongside the formal branches of IP law because many AI rights questions are shaped by agreement rather than by general law alone. When an organization uses an external tool, buys a dataset, licenses a model, or engages a vendor, the contract may define whether prompts are retained, whether outputs can be reused, whether the provider can use company inputs for model improvement, what rights the customer gets in generated material, and what obligations exist if there is a dispute. That means the legal shape of AI training and use is often built not only by statutes and court decisions, but also by the actual documents the organization agrees to in procurement and deployment. A beginner should hear this clearly. The friendly interface of a tool does not tell you the whole right story. The agreement behind the tool may matter just as much as the technology itself. Governance becomes stronger when organizations review those terms before adoption, align them with internal policy, and teach users not to assume that every useful tool gives the company the same rights or the same level of protection. This is why internal policy matters so much. A company cannot expect ordinary employees to interpret complex IP issues from scratch every time they draft text, generate images, summarize a report, or experiment with a code assistant. It needs clear rules that explain what source material may be used, what confidential material must stay out of external tools, what kinds of outputs require legal or managerial review, and what uses are limited to internal experimentation rather than external publication or product inclusion. Those rules should also reflect the reality that different use cases carry different levels of risk. Using AI to brainstorm ideas inside a team is not the same as using it to generate customer materials, release production code, create training datasets, or develop branded creative assets. A good internal policy translates complex IP principles into operational guidance that employees can follow under time pressure. Without that translation layer, Even well-intentioned workers may expose the organization to risk simply because no one told them where the important legal boundaries were. Human review is one of the most practical controls in this whole area, but it must be real review, not ritual approval. If AI is being used to generate code, marketing copy, customer communications, internal policies, training material, images, or product language, someone needs to examine the output with the right level of care for the stakes involved. That review should ask whether the output seems too close to known material, whether it contains protected elements, whether it reveals confidential information, whether it fits the license and contract environment surrounding the tool, and whether the organization has the rights it needs for the planned use. In lower-risk settings, this may be a light but deliberate check. In higher-risk or outward-facing settings, it may require formal legal, brand, or technical review. The important beginner lesson is that AI generation changes the speed of creation, but it does not remove the need for judgment. The organization still stands behind the result, and someone has to own the decision that the material is ready to use. Another important theme is that IP law shapes not only what organizations should avoid, but also what they may want to protect. Companies use AI not just as consumers of other people's material, but as creators of new knowledge, products, processes, and branded assets of their own. That means governance should think about preserving internal rights as well as avoiding external infringement. If employees are using tools in ways that blur authorship, weaken secrecy, or place valuable work into systems with uncertain contractual terms, the organization may compromise its own IP position. A strong program therefore asks which projects should stay inside controlled environments, which creative or technical workflows need tighter oversight, how invention disclosures or trade secret protections interact with AI-assisted work, and what documentation is needed to show human contribution and organizational ownership where that matters. This is a more strategic way to think about the topic. IP governance is not just about fear of getting sued. It is also about protecting the value the organization is trying to build as it adopts AI at scale. As you finish this lesson, keep one practical idea in mind. Intellectual property, IP, law shapes AI training and use because AI systems rely on material created by people, generate new material that may carry rights questions, and interact constantly with licenses, contracts, confidentiality duties, branding concerns, and the organization's own protected knowledge. Copyright influences what content may be used and how outputs should be reviewed. Patents matter when AI helps create or implement technical solutions. Trade secrets matter whenever confidential know-how touches an AI workflow. Trademarks matter when generated material reaches the public under a brand. Contracts and internal policy connect all of those ideas to daily operations. Once you understand that, the deeper lesson becomes clear. AI is not just a technical capability. It is a rights-sensitive environment, and responsible governance depends on treating those rights seriously before the model is trained, before the tool is adopted, and before the output is trusted enough to leave the organization and enter the real world.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.